Hi, good evening, everyone. Welcome to this session I would put it a little differently, arbitration versus insolvency. I'm always on the side of arbitration. You can take that from me at least. I'm Naresh Thacker. I'm the moderator for the evening. Now, let me tell you, as a moderator, you don't really get to speak too much, so I'm going to take a couple of minutes, telling you, giving you a backstory of how actually I landed up with this panel. This is not a panel that I had chosen originally. I have I can see quite a few familiar faces in the crowd. And I can tell you all of them are arbitration practitioners, and they are going to ask me this question, why insolvency? So, Nish, I'm only on the arbitration side. I've not moved towards insolvency as yet. But, when Neeti came up to me and she said, oh, Naresh, and obviously when Neeti comes and she talks to you, she, smiles very, very sweetly. And she said, Naresh, I want you on a panel. And I was like, oh, great, she wants me on a panel. So great, I said yes without even thinking. And then the topic came up and it was arbitration vis-a-vis insolvency. And I was horrified. I said, Neeti, no, this is not something that I'm going to do. You can't get me on a panel which is on arbitration and insolvency. I will only be, talking half. The other half, someone else will have to do it. So she smiled, more sweeter, and this time she tells me, don't worry, I'll make you the moderator. So that's the moral of the story. Always know the management. They can work wonders. With that, let me now start with the introduction of the panel. We have a stellar starcast for you. And I will begin with the introduction in no particular order. But first, we must begin with Yuet Min. Well, she is the lady on the panel, and she comes also from outside the country. So as a good host, I'll begin with her. She's a disputes partner at Drew & Napier in Singapore, handles commercial disputes both in Singapore courts and in arbitration. Particular interest and experience in multilingual proceedings. Was a young MCIA steering committee member and has held various positions in the committees within SIAC. She also co-chairs a committee in the ICC Singapore Arbitration Group. And I have, emphasizing on the word arbitration. Welcome to a panel on insolvency with arbitration. Next to me is Sidharth Sharma, who is a general counsel of the Tata Sons, an important man to know for this room. That obviously, as all of you know, Tata Sons is the principal investment holding company and the promoter of the Tata Group of companies. One of the largest Indian business conglomerates. As a general counsel at Tata, Sidharth heads the in-house group, that's the in-house group legal function, and advises the group companies and Tata leadership and senior management team on a variety of legal issues. Next, let me introduce Kiran Sequeira. Kiran, if you can just put your hand up for the audience. Thank you so much. Managing Director at Secretariat, where he serves as an expert witness on financial, economic valuation and damages issues and complex international disputes. He has provided expert evidence in over 100 commercial and investor state arbitrations, of which over 25 matters involve Indian companies, and that's phenomenal, Kiran. He has testified in some of the largest and most visible international disputes across the globe, particularly in capital-intensive sectors such as energy, infrastructure, and mining. Next up, Jagdeep, seasoned legal professional with diverse professional background, encompassing 16 years of experience serving as in-house counsel, and has experienced working across sectors with stints in Hindustan Lever, IBBO Group, and currently he works with the Vedanta Group as Deputy General Counsel. Last and never the least, Amit, who is a disputes and forensic, who is a partner with the Forensic and Dispute Services practice at Deloitte. He leads the Disputes and Litigation Advisory Service and Antitrust Services, wherein he has worked on over 80 commercial dispute engagements requiring expert intervention in computation of claims, expert assessment of counterclaims, delay analysis in construction projects, forensic audit of financial statements and termination of commercial contracts and gathering of evidence in litigation matters. So that's a impressive panel that we have here. Begin with the questions because we have, as I was told, only 55 minutes to run through all the questions that I have. My first question is to Sidharth. Sidharth, when one of the parties to an arbitration is insolvent, the dynamics of arbitration, as we understand, can significantly change. What is the scope and impact of a moratorium under the IBC on arbitration proceedings against the corporate debtor? What would happen in such a situation where you have a moratorium under either Section 14 or Section 96 of the IBC?
Thank you. Thank you, Naresh, and good evening, everyone. It's my pleasure to be here, and I speak not as an expert, but as a member of the legal community. And I know many in the audience, they're experts in the field, and so I don't claim any extra expertise. But this topic is interesting, arbitration law is interesting, and insolvency, especially in India, is very interesting because it is an evolving subject. It is, I can say, despite a very lengthy legislation, detailed legislation, it is primarily a court-driven law. Much of the clarifications and how the law has evolved has come through judgments. Now, moratorium is again one part of the legislation which again has been subject matter of debate, ambiguities, and inconsistent decisions. I think much of the issues in any branch of law becomes clear if we, Naresh, if I'm just taking I'm making this preface because, you know, in this forum, we are not issuing a legal opinion to somebody. We don't have to exactly discuss what the law is. I think ideally we should discuss what the law should be. And so the ambiguity surrounding moratorium provisions in the Indian IBC, I think much of it will be clearer if we look at it from the point of view of what the object of IBC is. And put it very, very simplistically, I feel corporate insolvency resolution process is nothing but a controlled M&A supported by court and a state legislation with one policy objective, which is to keep the business of corporate debtor in business. Because the alternative, which is liquidation or the corporate death of the corporate debtor, is not a desirable situation for anyone. And that is why it's a chance that one takes at resolving the insolvency and to revive the corporate debtor. Now, if this is the objective, then it's very important that the corporate resolution, insolvency resolution, is given a best chance. And the entire focus of all the stakeholders is on that process. And that is why moratorium is important, because if moratorium is not there, then it will lead to chaos. Now, if we look at it with this perspective, then I'm not talking about the cross-border situation where you have an international commercial arbitration, but strictly speaking within the scope of the Indian law, I think any action or proceeding against the corporate debtor has to be stayed, and the Indian law is very clear, three things. You can't institute, you can't continue, and we can't execute if you have a decree or an award. So there are different layers within it. What if there is a claim by the corporate debtor, but there is a counter claim by the defendant? I will come to that perhaps in the second round, Naresh. But as things stand in the Bare Act, action proceedings against the corporate debtor is covered by the moratorium, and which is again very clear if we look at the other provision in the same act, which is the moratorium provision that kicks in when resolution has failed and the corporate debtor goes into liquidation. There, section 33, subsection 5 of the Indian law makes it clear that there the moratorium applies both in relation to action by or against the corporate debtor. So while CIRP is on, this is the effect of moratorium under the Indian law. Thank you.
So interesting, as what you've put, Sidharth, I think there is one clear issue which emerges. In an arbitration, here is a party autonomy that you're speaking of, as against a collective that you need to protect under IBC, and that's the true dichotomy when you look at arbitration vis-a-vis insolvency. And the question truly always is that how do you resolve this problem? Yuet Min, if I can ask you this question from from an international perspective, I think, Sidharth spoke about the domestic scenario, and he said that, if there is a moratorium, in that moratorium, nothing can happen vis-a-vis the company. Everything comes to a standstill, and the reason why it comes to a standstill is because you need to protect the assets. You need to ensure that there is a positive revival as against a liquidation. But let me, narrate a hypothetical situation for you, and let's understand from an international standpoint, how would this work? Let us also agree that there are no reciprocal arrangements between our respective countries on the cross-border insolvency. Now, a corporate debtor is undergoing insolvency proceeding in India. In or around the same time, you have an international commercial arbitration which is seated in Singapore. The governing law is, let's say, the Singapore law. And, in that situation, the debtor comes to the Singapore tribunal and seeks stay on the ground that there is a moratorium back home in India. In that situation, how would you think that the tribunal would react? Would the tribunal grant stay, or would the tribunal say that nothing doing, I'm going to go ahead with these proceedings? And let me also give a further twist to it. Assume also the situation that, if I take it, now I would want to know the yes or no of why the tribunal would, if they would grant the stay, then what is the reason? And if they would not grant the stay, then what do you think would be the reason why, they would do it? And then maybe I'll come with a further twist to that question.
So I think my general sense of how this happens, and it happened like only once in a case that I was on, but generally it's actually quite difficult to stay an arbitration proceeding governed by Singapore law. If, let's say, in the hypothetical, there was an insolvency proceeding in India. There is always a question of like how that insolvency proceeding arises. I think there are some questions about that. But generally, if there is a valid arbitration agreement, it would generally be very difficult to have to stay in arbitration because of an overseas moratorium or insolvency proceeding. But there are cases where I think we've seen cases where there is a stay, and I think usually that involves public policy reasons. If other creditors will be prejudiced, then that may be one of the factors that a tribunal may take into account in staying the proceedings. But I had a case once long ago, and it happened in the middle, on the second day of the hearing. The opposing side came, so they have already argued one day. The second day they came, what happened, that was not an Indian insolvency proceeding, but they had filed basically for like insolvency proceedings in the US. And they basically just said, and then they walked out. They walked out of the arbitration. Basically they said, I have no instructions, I'm going to walk out. So we did research on the spot to persuade the tribunal to continue with the arbitration in the absence of the respondent. And we managed to convince the tribunal in that case to continue. Of course, this was before the time now, insolvency is such a global action nowadays, so it may be a bit different now, I think, because this happened more than 10 years ago when this happened. But I think the general position, and I see there are like Singapore experts here, but I think the general position is that it will be quite difficult to stay a Singapore arbitration proceeding because of that.
So, we all understand and we all know that Singapore, as a jurisdiction, supports arbitration, and especially if it's an international arbitration, they will go all out and in support of the arbitration proceedings. We've seen that happening in a, maybe slightly unrelated issue, which was Anupam Mittal, and there, despite the fact that there was a operation and mismanagement proceeding which could have happened in India under the statute, the Singapore tribunal, the tribunal first decided to go ahead, and then all the way up to the Supreme Court, it was held that, the arbitration ought to go on, and, it ought not to stop merely because, there is a statutory, bar in India to take it into arbitration. So my own sense also would be that, Singapore will support, arbitration and would not merely on the basis that there is a, insolvency proceeding in India, stay anything. I must also, put this across. We also do understand one thing very clearly in India, that the IBC as a act applies, if you look at Section 1, it applies only to India. So it clearly does not have the extraterritorial jurisdiction. Until and unless there is a reciprocal arrangement, there are two provisions within the IBC, Section 234 and 235. Neither of them have been given effect to as of now. The notifications have not, neither notifications have come out, nor is there the reciprocal arrangement. So therefore, my thought also would be that the tribunal will not stop. But let me, just twist that scenario a bit. Assume for a moment in the factual scenario that we've spoken about, the Indian courts were to grant a stay. In that situation, would the tribunal honor that stay? And if yes, then what would be the consideration? If no, then, what considerations, on what considerations they would not honor it?
Yeah, so see, that's quite an interesting question, because I would imagine that, I think if parties agree, the tribunal will probably just, stay the proceedings. But there's an issue of enforcement here. Because in Singapore, unless, as you say, unless there's reciprocal arrangements, usually enforcement is only for money judgments. So when you have to enforce something that's not a money judgment, it's actually not that easy to get that enforced in Singapore, so even if there's an injunction. But, coming back to the Anupam Mittal case, even before, I think that recently there was about 2 weeks ago, there was an Indian court judgment that I think sort of went against the Singapore decision. But I think even before that, if you read the Singapore decision, and I think most Singapore practitioners may agree with me, that it's actually going to be a very difficult decision to implement. Because if you bring that decision all the way to its logical conclusion, you won't be able to enforce that award in India, which is probably the place that you're going to enforce it in. So, you come up with a circular problem, so you may be able to insist on arbitration in Singapore, but it may lead up to future problems of enforcement in the very jurisdiction that you want to enforce in. So I think, and I'm not sure, of course it's a court of appeal judgment, it's going to be difficult to move away from that. But if you look at the judgment, it distinguished an earlier judgment, which B&A, it distinguished B&A. And if you look at the facts of the two cases, honestly, I can't really see the difference. But because in that case, the court went the other way and said that it was PRC. So actually, I'm not sure how far we can take Anupam Mittal. It seems to be a decision that is very difficult to implement, and I'm not sure realistically it is a good decision. My good friend was the amicus curiae in that case, and I unfortunately disagreed with him. So I think it's a difficult. I think that it's not going to be an automatic stay, even if there's an Indian court injunction.
Yeah, one thing we all learned from this Singapore experience is that every court across the world, when it comes to jurisdiction, their own jurisdiction, they do react in a certain manner, and you're right. The decision of PRC, if I mistake not, that was para 18 of the judgment, and they've reproduced a part of what PRC the facts was, and the facts were quite similar to Anupam Mittal. So what was truly the reason for them to move away from that scenario is quietly not, I quite don't understand why they.
I think there was like one paragraph, and then they said that you can see how it is very different, and I'm like, no, I can't really see why it's very different.
And also the point of enforcement was brought in by.
Even in B&A, it's a problem because the High Court and the Court of Appeal had different decisions.
Yes.
It was actually overturned, so you can imagine how it's very difficult to gauge in these situations where it's going to go.
Yes. So moving on, Jagdeep, if I can, pick your brains on this issue, that what, according to you, is the Indian view? Does the moratorium that is imposed under Section 14 and 96 act as a bar on the continuation of arbitral proceedings that are seated outside India? If your answer is yes, then what and why would you think that such a situation ought to arise, and why do you think that the arbitral tribunal ought to hold its hand?
So thanks, Naresh. I think Yuet's answered it to an extent in terms of the practicality of it. I think in terms of depending upon what positions being taken over here, if the tribunal decides to continue with the arbitration, I think there'll be, in terms of the practical outcome of it, limited things that anybody will be able to do. But I think she brought out another very important point, is that the CD could just take a call and not participate in the arbitration at all. I think from a practical perspective, that becomes very important, because even if you get an award, I think the moment you obviously bring it over here to try and enforce it, I think that's where the moratorium anyway is going to kick in. So I think the resultant outcome is going to be similar in terms of what you achieve out of it. So I think that practicality of it becomes very, very important in terms of how you deal with it. But I think what Sidharth also mentioned earlier, that I think and you also mentioned in terms of the applicability of the law, I think because it's anyways restricting to the territory of India, and in terms of this entire the continuation of your arbitrations as well, I think it's still something which is developing, but I think we'll have to look at the practical aspect of it in terms of how it will eventually get enforced. So I think the outcome's going to be eventually very, very similar. I think that's probably how it's going to, unless there are changes, and as you said, that we have arrangements with other countries in terms of the enforceability and all, I think we'll probably be facing this issue for a little while.
So, Amit and Kiran, sorry, before I come to you guys, one question that I want to, ask Sidharth. From look at it now from the corporate debtors perspective. So, would an institution of a moratorium mean that the corporate debtor also should stop all proceedings, or can he or she continue to initiate or to continue litigating and do whatever is required for the purposes of securing the company's dues?
So no, obviously the moratorium is intended to be a shield, and again, going by the object of the act, the insolvency law is to protect the corporate debtor from onslaught of claims, so that resolution applicant which is there in the market, who is willing to come and resolve it, take over the company and run it efficiently, is not scared. So, but the converse is not true. So actions by the corporate debtor is of course allowed and should be allowed. Now, but there can be nuances. What if I am the corporate debtor, I make a claim, and in an arbitration, I have an award in my favor, but then the counterparty challenges that award under Section 34 of the Indian Arbitration Act. Now, whether that 34th challenge can continue during the moratorium period or during the CIRP process. Now, Delhi High Court has held that it can, and I think that's the correct view, because if a party is taking an action which is pure defensive, when corporate debtor is suing somebody, and if that is allowed, then of course the counterparty is defending itself. And that defense logically should continue to appellate proceedings, which in case of an arbitration, it has to extend to the proceedings where an application for setting aside of the award is involved, because it's just a defensive proceeding. There is a paragraph in one of the Supreme Court judgments of the Indian Supreme Court where it says that the Delhi High Court, what Delhi High Court decided is not the correct law. Section 14 is very clear. Any proceeding has to be stayed during moratorium. But again, with respect, I feel that as a pure student of law, I don't think there is enough discussion in that judgment on this issue. a pure defensive proceeding should be allowed to be continued. The problem arises when corporate debtor sues and the counterparty makes a counterclaim. Now there again, the judgments say that it can continue, but the moment the counterclaim is allowed, then the moratorium kicks in. So it's very contextual. It's not hard and fast rule that you switch on you put the switch on and moratorium should kick in and it should go away in a particular event. So it's very contextual, logical, and this is the way it should be. I just had a question. I was just wondering that let's say where a counterparty or a claimant against the corporate debtor makes a claim in an arbitration which is purely for injunctive relief. Let's say the corporate debtor is in breach of confidentiality obligations. Or in a joint venture situation, the corporate debtor is in breach of non-compete obligations. Whether the counterparty can run to an international arbitration, invoke its emergency arbitration provision, and get an injunction even when a moratorium is or CIRP is on. So declaratory reliefs, whether that can be considered during moratorium.
No, that's a very interesting question that you put, and I think there is no straightforward answer to what you ask. It ultimately, to my mind, I mean I don't know what Yuet Min or anyone else on the panel would have a view on this or not, but to my mind again it will all depend on what is the impact of that injunction vis-a-vis the corporate debtor. Because if the impact of the injunction is anything which is financial, and that's the whole purpose of IBC, it's the financial revival of the company. And if it has any financial implication, obviously this is where the courts will go into this question of understanding what is the financial implication. And depending upon that, it will, either the injunctive relief will be granted or will be denied. So can we put it in any straitjacket formula or an answer? I don't think, there is any straitjacket formula or answer. But Yuet Min or Jagdeep, anyone who on the panel, please feel free to add to whatever I have said, or, to take the question that Sidharth has put forth.
Actually, I agree. I mean, already in Singapore is unlikely to, the starting position is that it's unlikely to have an impact. But I think if what is in arbitration, what is in dispute, is completely non-financial, then I suppose even more so, it won't have an impact. And as I was researching, as I say, I'm not an expert in this area. As I was researching the issue, I also thought, even if the issue is purely arbitrable, and therefore the arbitration proceeding continues despite insolvency proceedings, wouldn't there also be a concern about, the fact that the company is like spending money on an arbitration? But the costs don't seem, I tried to look at the cases, but they don't seem to take that into account. I should also add that I think in the Singapore context, I think what some parties do when they can't get the Singapore proceeding stayed is that they then go to court, and I think they get a Singapore court moratorium. Because I think if you fit under the requirements for like Section 64 of the IRDA, you get like an automatic moratorium, like 30 days. And I think that's within Singapore context. I think the tribunals will have to respect that because it's an automatic moratorium if you fit within Section 64. I think in restructuring situation.
So one interesting point that you also mentioned was that if the counterparty was to seek to challenge the award in a 34, what would happen? My own sense is that in the 36 there, so you're right, in the 34 the moratorium should set in, but under 36 the amount ought to be asked to be deposited by by the counterparty, so that money can be brought into the corporate debtor company. So to my mind, that is something that should happen, because otherwise, what's the point? You have an award for the corporate debtor. That award today is challenged, and there is the moratorium. Because of the moratorium, you stop the proceedings of the corporate debtor. But at the same time, if the money does not come in, it does not help.
But the money has to come in accordance with law. I mean, moratorium is supposed to protect what the corporate debtor has in its kitty.
Correct.
It's not supposed to allow any and every claim of the corporate debtor which it files against anybody. Otherwise, you're killing the defense. So I think.
So somewhere the balance is to be found. You're right. And to my mind, under a 36 application, and just for everyone, benefit here, the application under 36 is made when you are seeking to, you're seeking a stay against the arbitral award. Now, if this is a counterparty which has challenged an award and it's an award in favor of the corporate debtor, then one thing is certain, that that money needs to be deposited in court, because even otherwise, like any money decree, and we all understand that a money decree needs to be paid, and courts seldom ever grant any relief, more so an injunctive relief. There could be that the corporate debtor could be asked to give some sort of a guarantee, but in this situation, more likely not. And also likely, most likely that the money will be asked to be brought in. But anyway, quickly moving on to our next question and the other two panelists. Kiran, if I can ask, of you this question, that in situations where an Indian company in insolvency proceeding is also a claimant in an arbitration, how does the parallel insolvency proceeding impact the arbitration proceeding from both the causation and damages perspective?
Thanks, Naresh, for the question, and a pleasure to be here alongside my co-panelists. I should preface my response by saying that my comments are informed by my experience in international arbitrations, where one of the parties is an Indian party that is also in an insolvency proceeding. And I think what makes the damages assessment somewhat different in these cases is that it needs to be preceded by what I call a causation analysis, where you need to evaluate what would be the financial position of the claimant but for the alleged breach, right? If you're in a contract dispute, it would be but for the contractual breach, but if you're in an investor-state arbitration, it's but for the breach of the BIT or public international law. And so I think that's oftentimes not a simple analysis, right? You could be in situations where, let's say there's a breach of contract and the supplier simply stops supplying your raw material, there's no substitute raw material. And so in those cases, you could say pretty easily, but for that breach, you would be continuing to operate. But many times it's far more complicated. There are competitive pressures, the company is over leveraged, there's too much debt, and on top of that, you have a breach, right, of the counterparty. And in those situations, I think you really have to carefully model and simulate what would have happened to this company but for that breach. And the reason it's important is because the damages methodology is very different if you're valuing a company on what we call as a going concern basis, assuming you would continue to operate and generate cash flows, versus valuing a company when it is in insolvency, where it's either proceeding into restructuring and resolution or going to liquidation, right? Those situations, the value can be substantially lower. And so I think the answer to the question is really it's a two-pronged kind of process in these types of cases, where the first step is to assess kind of causation from a financial perspective to determine whether the company would be insolvent or not but for the breach. And based on that determination, that would inform the damages methods you use. For example, if you are going to be a going concern, you would use a discounted cash flow or a market approach. But if you're going into insolvency, then it may be either a liquidation value or a restructured company with a new capital structure that you'll be using to value the company.
So Naresh, I'll just like to add here, and let me caveat myself, in terms of I'm not an IBC expert, but I kind of work more as a financial expert. And I'm talking of a live example where we are currently working on, and this is a large infrastructure company which has multiple projects, and one of the projects happens to be disproportionately large, and where the concession agreement has been terminated. So it has a disproportionate financial impact on the overall company. Now we have a situation here that if, let's say that there is an arbitration which is already on, the client has already got the first award in its favor, which is for the delay side, which means the delay has already been established. However, the situation of the company is such as a prime candidate for bankruptcy, for filing bankruptcy. Now, this is a situation where, they have to take a decision whether to continue to fight the arbitration or to file for bankruptcy. And this is, the lenders are supportive of the company. They're actually seeing that situation. That yes, whatever the company has been telling us is a live situation. However, it's a very difficult decision. And they are taking our assistance to kind of say how much is a possible claim which can come so that they can take a decision whether they should actually go for bankruptcy or continue with the arbitration.
I take it that you are being paid for the work that you're doing, despite this difficult situation that the company finds itself in.
We have been appointed
I'm sorry,
by the lenders, that's right.
So, Amit, I'll stay now with you. Can I ask a question that, can a party in an arbitration proceeding file a claim in the corporate insolvency resolution process? Is it possible?
The party is the counterparty, one of the...
Yes.
Okay. So, because the moratorium will kick in, while they are welcome to file the claim, but if the claim happens to be on the disputed facts, very, very unlikely that the resolution professional will admit it. However, if there is a claim which is beyond the disputed items, which is in the routine nature, that is something which the resolution professional may look at. And they may, subject to verification, they may admit it.
So what, okay, just for our understanding, so what you're saying is that if it is something that is already a part of the arbitral process and would require some sort of an adjudication by the tribunal, that is not something that one can bring before the IRP, and the IRP will therefore look at everything else but that claim. Okay. Jagdeep, if I can ask a related question. We've moved ahead now and we have an arbitral award. Question is that, does such an arbitral award or a decree qualify as a debt? And what is the nature of the debt? Is it operational? Is it financial? And therefore, basis which, if you were to take it before the IRP, what sort of treatment would he or she give to it?
I think two things over here. I think I'll also distinguish between one, just filing a claim before the IRP, and secondly, to actually being able to initiate the IBC proceedings as well. So I think let's look at that as well. I think as Amit rightly mentioned, I think in terms of filing the claim, I think all those factors will be taken into account. In terms of your specific question, in terms of the award being there and whether they can use it to file the claim, I think anyways, if you look at it from a foreign award perspective, I think it's important that it will first have to be brought into India, get enforcement done, and then only it will become debt. And I think that's the position which has been laid down now. So as long as it is disputed, it will not be considered a debt, and therefore, at least from your position of being able to initiate the proceedings or file a Section 9, I think that's where it will not be possible till you are able to conclude that process. And in terms of filing of claim, as Amit mentioned, I think it will depend upon a lot of factors. To give your answer to your other question in terms of your what kind of debt it will be, I think that will again be dependent upon the circumstances in terms of your dispute, whether it's an operational creditor or a financial creditor, and depending upon which is the counterparty over there, and what kind of debt it will eventually get considered. So I think that's how that bit will get considered. But I think you will have a slight difference in terms of how it will be considered, whether you are initiating the IBC process or you are just filing a claim. I think initiation will become a lot more difficult for a party who's having just the award and has not really done any enforcement or rather not converted into a decree as such in India.
So yeah, I think from the perspective of whether this is a debt is a financial or operational debt, especially when you have an award or a decree in front of you, I think the question becomes more nuanced and maybe more complex when it can be given either of the treatments, it has an element of both. Then the question is, does the entire debt become a operational debt or a financial debt? Obviously, from the creditor's perspective, they would always want it to be a financial debt because, in terms of the waterfall mechanism, you stand way up and then, but as an operational creditor, you're not going to get anything. So they, one is going to look to, place it always in the financial debt category, but it's always going to be a nuanced argument. And I do not think on most occasions, whatever the IRP decides, to my mind, it is always going to land up in the NCLT, and then it will be left to the NCLT to decide, what is the nature of the debt. But Kiran, would you have any comment on this?
Yeah, I think it's a tough one because, if you look at, the question is, do you pierce the veil of the award and understand how that damages was calculated, right? Because you can have an award you can think of an award made up of sort of different pieces. There may be recovery of past receivables or dues, which one could perhaps consider as a financial debt. But then you've also got, other elements, working capital changes in, other operational issues that, you think of that also contributes to the damages claim. That may be an operational debt. So the question becomes, does the trier of the facts break into the damages award and assess how those claims were calculated, or they treat the entire award as just one asset, so to speak, and then label it as one or the other? And like you said, I think that discretion would lie with the NCLT and how they construe that award.
Sidharth, coming back to you, and this is a question which I think, usually is there in the minds of everyone when, you see a corporate resolution process, that a company undergoes. Does a resolution plan provide the company with a clean slate? Is now all sins wiped out and I am as what, I don't know if anyone here would understand it, but, if I was in Mumbai, this is a very easy thing to explain. What the Jains usually do every year, they go through a process and then they would tell each other, Michhami Dukram, which means that I wipe out all my sins and I begin once again on a clean slate. So is that what it means, or would it mean, something else?
I think from resolution applicant's point of view, clean slate has to be there. I had read, after the financial crisis of 2008, there is a very good book, Too Big to Fail. And there is a chapter, the whole Lehman Brothers collapse and everything. And there is one where the author has explained what happened when Lehman filed for bankruptcy. And in the bankruptcy court, Barclays put in the bid, $1.75 billion for the whole North American operations of Lehman. And many creditors opposed it. It's written that the proceedings went late into the night, and at midnight the judge approved the plan, the so-called bid. And he said that I am approving this plan not because it is the best plan, because it's the only plan available. IBC is not to give everything to what is due to everyone. And corporate debtor is like a melting ice cube. Every day the value is chipping away. So you have to close it quickly. And what is a resolution plan? In simple terms again, resolution plan is nothing but a contract, an offer to contract which an applicant gives to the COC that on these terms, I want to acquire this company. And once that plan is accepted by the committee of creditors, it is approved by the tribunal, the insolvency court, then the plan has to be the Bible. Then if you keep uncertain claims, if you burden the resolution applicant with future claims, even though the plan says that all prior claims shall stand extinguished, then where does it end? No resolution will ever take place. And this happened mostly in cases of tax claims, and I can say it with experience because when we acquired Bhushan Steel, when Tata Steel acquired Bhushan Steel through the IBC process, everything was there. Plan said that all claims relating to period prior to the CIRP shall stand extinguished. We are not liable. But still we got different tax claims from different state governments, income tax, and one by one, we fought, and we've got favorable orders. And Supreme Court clarified in Ghanshyam Mishra judgment where they approved this clean slate principle because you can't have, no contract can have an uncertain consideration or unlimited consideration. If resolution applicant doesn't get a clean slate after the approval of the plan, then where does the process end? So I am a big votary of this. Recently, there have been some Supreme Court judgments which have tried to disturb this principle. Rainbow Industries, where tax claims were, Supreme Court said that they will have priority because under the tax law they have a charge, and therefore Supreme Court tried to give that priority. Thankfully, that has been corrected. Rainbow is under review, but in a different judgment, I forget the name of the judgment, but Justice Ravindra Bhatt has said that no, it can't be. Because once you have a concept of waterfall, there is an inherent inequality in the system. And that is the reality of the business. Financial creditor, secured creditor will have priority. Financial creditors will have a claim when they approve a resolution plan, and therefore a resolution applicant tries to fulfill that demand first. And therefore, it has to end somewhere. And that is what clean slate principle affirms and should be affirmed. Thank you.
Good that you mentioned that. I remember the time when there was no IBC and we all used to file all the winding up petitions, and usually the winding up petitions would stay within the Indian court system for a very, very long time. And in between, you'll have the tax guys come in and say, but I have the first charge. And everything would be disturbed. And courts in India, usually, unfortunately, many times they become like recovery agents. Some courts would say that, okay, if it's a PSU and or if it's a tax authority, and then in that case, and if they have the first charge, and I remember, cases, one of the old matters of Punjab National Bank versus, one of the companies, and it was a customs case. And PNB, as we know it, came in to say that, oh, but I hold the first charge. And therefore, in the waterfall mechanism, whatever the statute provides becomes immaterial, because I contractually, I hold the first charge, and therefore I should have the first right of call on the asset of the company. So yeah, you're right. Now at least there is enough and more clarity in the system. So Yuet Min, if I can very quickly come to you, we all understand that a insolvency process is not to be, you don't go down the insolvency process just because you need to enforce your award. That's not the process, and that's how the courts in India, look at anything which is brought in by way of insolvency, especially if you're trying to enforce your arbitral award. So the courts would usually tell you that, that's not the method. There is another method of enforcement, as one understands. So how would you, say that the Singapore courts would maintain equilibrium in a scenario where you need to balance out the equities on both sides? On the one side, you have an arbitral award, a person who holds an arbitral award. He seeks to enforce it, and the counterparty does not, follow through. And on the other hand, there are allegations to say that, oh, but there is a dispute vis-a-vis this very award. How would they, how would the Singapore courts maintain such an equilibrium?
So I don't think it's the case where if you come to court and just say that, I need to wind up or anything like that, the court will just allow it or anything, or in that vein. But I think there are certain safeguards, I think, put in place. The debtor will still have to show a certain, a certain bona fide of what they're trying to say, right? So you have to prove a certain bona fide. And if, let's say, that is, I suppose if that passes the threshold, then the court may also still get a certain undertaking. I think that's what sometimes it happens. They get a certain undertaking from the debtor, even if they allow the claim to go on. There's a certain undertaking, and then the winding up proceeding sort of revives itself at the end, so that there's some protection for the creditor as well. That's how I understand that the court sometimes do these things. So there's some discretion to how they manage these situations to balance the I suppose the rights of both the creditor and the debtor. I'm not sure whether similar things are done in Indian courts.
So I wouldn't say that, it is similar or identical. As I said, I mean, the courts would ultimately have, give its own consideration as to whether, it's an abuse of process per se. That's what that is how the courts would look at the issue, rather than, the manner in which you put it. But clearly, if the courts find that, this is an abuse of process, and, what the award holder is seeking only to do is to, enforce its debt through a circuitous route by trying to come under the insolvency process, then clearly, such a petition would not be entertained. Well, I have just a minute, and Kiran, I'm going to come to you. Unless there are questions from the audience, I do have a question for Kiran, but if there are any questions, we're happy to take it. Well, not really. We've covered everything well. But anyway, I do have a question for Kiran. Kiran, can you very briefly, comment on how damages experts should go about undertaking a causation and damages analysis for the purposes of an arbitration claim?
Yeah, of course. Thanks. So I would say, as I mentioned earlier, that in these situations where you have a parallel insolvency proceeding, the causation analysis is important, but the causation analysis has I see three legs. There is a financial assessment which we as damages experts do, but there's also legal and factual issues, right, that affect the outcome of causation. And so I think the goal of the damages expert is to really give the tribunal a roadmap on how to navigate those issues. And ideally, you want to entertain the positions of both claimant and respondent, right? Because oftentimes there are both legal and factual disputes between the two parties. So the tendency sometimes is to just take your view of your party that appoints you, or if you're a claimant expert, and just model out, the legal and factual position of, your client, and provide the tribunal with an answer. But I think the risk there is that if there is a different finding, right, on liability or on the disputed facts, you're not leaving the tribunal with any meaningful alternative. And so I think the key point is to identify those different scenarios, one based on claimant's legal and factual position, and one based on the respondent's legal and factual position. Do a separate causation analysis on both those sort of assumptions, and based on the determination of that causation analysis, where you find out whether you're going to be insolvent or not insolvent in this counterfactual world where there's no breach, you would accordingly do a damages analysis for those different outcomes, so that the tribunal can kind of say, okay, based on their findings, there's sort of a decision tree or a roadmap for them to get to an answer on damages.
So thank you so much, Kiran. And with that, I think we'll come to an end. The time's up. Neeti sitting here is not looking very happy with the fact that, we are 1 minute up, 4 minutes beyond time, but to me, it's just one. Anyway, but thank you so much for being such a patient audience. We have had a, excellent discussion. We enjoyed it. A round of applause for my panelists. Thank you.
Thank you, Naresh.